Hi, good afternoon. My name is Zach Mundy, and I'm the director and attorney at Graduate Student Legal Aid. And today we're going to talk about the end of your lease and what you can do, what your options are, whether it's early termination if you haven't made it to the end of your lease, whether it's looking for a renewal, or whether it's moving out. Those are our most common scenarios for our students at this time of year, reaching the end of the academic year. And so, as I said, I'm from the Graduate Student Legal Aid Office, and we are located on the South Campus above the dining hall. And we can provide a number of different legal services and also help you if you get charged with cheating or plagiarism or academic dishonesty by the university. So feel free to reach out to us if you have any follow-up questions after this presentation. We're going to talk about all the different scenarios, as I said, leases, early termination, the notices that are required. That's probably the most important bit. And then moving out and getting your security deposit back. So first, something that's very important to know is that laws when it comes to landlord-tenant are set at many different levels in this country. They're set federally, both at the state level, the county level, and the city level. So you might have different laws from the state of Maryland, then Prince George's County, and then the city of College Park. And so it's important to know what your local laws are. Given where our students live, we're going to focus mainly on Maryland and Prince George's County laws. DC has different laws as well. So if you have questions about those specific jurisdictions and you don't live in Prince George's County, reach out to us and we can try to answer those questions for you. Though most of our grad students don't live in dorms, some of our undergrads do who may be watching this. So it's also important to know that dorms don't count as rental housing accommodations in the state of Maryland, so you're not going to have the same tenant protections. So that's just something important to get out of the way in case you're an undergrad watching this who lives in a dorm. It's important to know before you're thinking about early termination of your lease or moving out or ending your lease, what a lease actually is. At this point, you've probably signed a lease, you're probably living in a place already, but a lease is just a contract. A contract is an agreement between two parties. Here it's the landlord and the tenant, and every lease is a little bit different. There are some protections under the law, both from the state and from the county and even from the city of College Park or the city of Hyattsville, depending on where you live, that your lease can't change. You're going to have them no matter what. But there are different terms that can change. And so even if you have a friend who lives somewhere else or even in the same place, there's no obligation that you have the same exact lease terms. So it's important for you to know what your lease says and not what someone else has had in their situation. And so with that, we have two different types of leases. You can live by yourself, or you could even live in a group home but have a lease that only has your name on it. That's called an individual lease. In that case, only you have to make these decisions. You can decide to move out, decide not to renew, but in some cases you might be on a joint lease where you and your roommates have all of your names on the same lease. You've all signed the same lease. And in that case, it takes a little bit more planning when it comes to moving out and renewal, because some people might want to leave, some people might want to stay. And in those cases, you need to have those conversations with your landlord to see if there's the ability to replace some tenants or not. But we'll talk about that a little bit in the different scenarios as we go on. Now, if you don't know what type of lease you have, whether it's joint or individual, it's important that you read your lease. It's also really important that you read your lease to know the terms and provisions of it that we're going to talk about coming up when it comes to notice of moving out, when it comes to early termination and what options you may have. So if you haven't yet, hopefully you did when you moved in, but I know that leases are a little bit unwieldy in this day and age, and they may be 50 or 75 pages long for no real reason other than to confuse you. But it's important to read your entire lease and make sure you understand it. If you don't understand it, reach out to the Student Legal Aid Office and we can help you understand any of those confusing provisions. Now, the first option is maybe you figured out, I'm finishing up in May, my lease runs till July or August. What can I do? How do I get out of it so that I don't have to pay? The little bit of bad news is that most leases don't give you the right to terminate your lease early without financial penalty. Some of them might say you can just provide a 30 or 60 or 90-day notice at any time and get out early. That's really rare. So it's important to make sure you understand what early lease termination options you may have. But there's a chance you don't have any. And so in that case, it's about trying to figure out what works best for you. If you were to just leave and stop paying rent early, landlords can continue to charge you for rent, or if you don't pay, they could, in theory, sue you in court for unpaid rent until they're able to find a replacement tenant. They have something called a duty to mitigate damages, which means they must take reasonable steps to find that replacement tenant. But it's not always possible, especially in College Park and Hyattsville. There's a lot smaller rental population in the summer than there is throughout the rest of the year because of our students and fellows and scholars associated with the university. And so if they're unable to find a replacement tenant for those 2 or 3 months in the summer that your lease continues, they can still charge you for that, unfortunately. What options do you have? Well, we want to check our lease to see what ability we have to sublease or assign to find a replacement tenant. Because even though we do have a smaller rental population in the summer, it's not zero. There are lots of people who stay around, and we also have lots of students who are coming from other parts of the country to do summer courses, or interns who are working in DC, who have temporary jobs in DC that want to not live in the city and want to live in College Park, closer to maybe their friends who go to the University of Maryland. And so it's worth it to look to see if you have the ability to sublease or assign. In these cases, if it says that it requires landlord consent, in those cases, Maryland law says that the landlord cannot arbitrarily deny consent. So if it says that you can sublease or assign with the consent of the landlord can't just say no unless they have a valid reason. And those reasons are usually that the tenant you're trying to sublease or assign to are unqualified, meaning that they don't meet the same standards that you did when you moved in, whether that's about income, whether that's about the ability to pay rent for that time period, or in some cases maybe they were previously evicted or something along those lines, so that the landlord can choose to do that. But in most cases, if you find someone who is similarly situated to you in sort of like income and that variety, and they haven't been evicted in the past, the landlord can't say no if your lease does allow you to sublease with that written consent. Now, sublease is sort of often used as an umbrella term for any time that somebody's going to be moving in, but sublease is a slightly different legal term than assignment. Sublease means that you are going to remain on the lease and that someone else now has the authorization, the permission of the landlord to live there. Assignment is when your name will be removed entirely from the lease, almost like it'll be scratched out or deleted, and then the new tenant will have their name written in there instead. So you have cut all financial ties to the lease under the assignment. Assignment is more favorable for you, the tenant, less favorable for the landlord, because in a sublease, if the new tenant, the temporary tenant, stops paying, your name is still on the lease, so you can still be financially liable. In some cases, the landlord might not let you assign, and you might have to sublease, and so it's important to try to find someone or find someone that is trustworthy to make sure that you're not increasing your potential risk. Now, maybe you're not trying to get out early. You're just here at the end of your lease, or you're planning for the end of your lease, whether that's in June or July or August, and you want to know what's the best way to protect yourself. The most important thing you can do is provide proper notice. If you don't provide proper notice that you intend to either renew or end your lease, you might not have that option. If you didn't provide the proper notice to renew, your landlord might then give it to someone else, and you would have to move out. Or if you don't provide the notice in the right time frame, maybe you do want to move out, but your lease says it requires a 90-day notice and you only gave a 70-day notice. In that case, they can charge you for that additional time period, that additional 20 days, and you can't always force them to prorate, so then they could charge you for a whole nother month. So it's very, very important to look at your lease and figure out what kind of end of lease notice is required. As it says here, in Maryland and DC, it is common to have 60, 90, or even 120-day notices, even though a lot of places around the country or in your past rental history, you might have only expected a 30-day notice. So it's very important to know whether or not you have a longer notice provision, and set a Google Calendar reminder so that you provide that notice and don't forget about it. As I said, if you don't provide the notice required by your lease, your landlord can, and they will, charge you for that additional rent. This means that you can be charged for many months rent after you move out. So if you didn't provide any notice at all, you just assumed that you were going to move out on the last day of your lease term, because in some states and some jurisdictions, that's just how it works. But here in Maryland, that's not the case. And so if you didn't provide any notice at all and you had a 90-day notice requirement, they're gonna charge you for those 3 months. And so you want to avoid that as much as possible and make sure that you understand what the requirements are for the end of lease notice. Now, if you're thinking about renewing, it's important to provide that proper notice. But one thing to know here in Prince George's County is that there was a recent law enacted in 2024 that limits the rent increases in some housing. I say some because there are a number of exceptions. The most common ones for College Park and Hyattsville are listed here. But if you're in a building or a house that is subject to this rent stabilization law, then your rent increase is going to be limited to 6% or the CPIU plus 3%. So the CPIU is something that is going to change every year. It's based on the Consumer Price Index. And so just think of it as a 6% max, but in some cases it might be slightly lower. It might be 4.5%, it might be it was 5.7% last year. And so if you're in those buildings and your landlord says, I'm going to take your rent from $1,200 to $1,500, you might have a protection, and you can try to prevent that larger rent increase. If you have those questions, let us know. Reach out to us. There's also a representative for Prince George's County that's in charge of that, and we can provide you with their information as well. The most common exemptions to this law are buildings built after the year 2000, and so a lot of the newer quote-unquote luxury apartments that are around are not subject to this law. And then the other common ones are if there's a small landlord exemption, meaning that if it's not a large business, if it is an individual who owns 5 or fewer units, so they have to own it as a natural person. If you look up in the property records or come to us and ask us to do that for you, and it's owned by like an LLC or some sort of partnership, then that's not going to be exempt. But some landlords who own 5 or fewer rental units can be exempt. And if you're in one of the condominium towers close by, if the condo is owned by someone who lives in the county, then that could be exempt as well. But if your condo owner lives in Montgomery County or DC or out of state, then that's not going to be exempt. So there's lots of moving parts here, and in some cases, we can try to do some of the research or the property records to answer some of it for you, but in some cases, it's impossible to find out. You can't search by name on property records, so I can't find out if they own 5 or more. You'd have to reach out to the county to try to figure that out. But we can provide you with that information as well. So when you're renewing, make sure you provide the proper notice, and then also think about the rent increase. Even if you're not subject, so if you're not subject to this law, meaning you don't have those protections, you can always negotiate with the landlord. There's no obligation for you to accept the first offer. Some landlords are going to be a little bit more difficult to deal with, and they might just say no, take it or leave it. And if they're exempt from the law, that's kind of just how it's going to be. But other landlords may be more reasonable. And so you can always try to negotiate with them to get a lower rate, to get something more manageable, because renting in this area in Prince George's County, Montgomery County, DC, it's not cheap, as you know. And I know that I was super broke when I was a grad student, and so I know that those rent increases can really throw a wrench in your plans. Now, if you're not renewing and you're deciding to move out, It's important to always provide that proper notice. I can't say it enough, because if you don't, they're going to withhold your security deposit to offset those additional months of rent if you didn't provide the notice required under your lease. But say that you did provide that proper notice and you're moving out, your number one concern is probably your security deposit. We're going to talk about the basics of the security deposit law first, and then talk about how you can protect and try to make sure you have the highest chance of getting that security deposit back. As you can see, the landlord in Maryland has 45 days to return the deposit to you. They may withhold all or part of your deposit to cover damages that are beyond ordinary wear and tear, or for any unpaid rent or unpaid utilities or other fees. Now, the key phrase here is beyond ordinary wear and tear. If you spill wine on the carpet or some sort of red juice or fruit punch, that's not ordinary wear and tear if it creates that large stain. But if you're just using the carpet normally and walking the carpet 1 year after it was installed, or even 2 years, or in many cases this is 10 or 20 years, and you just had it for the last year, it's not going to look brand new. And that's what ordinary wear and tear is, just using the facilities, using the apartment, the home in a normal way where you're not doing anything to cause excessive damage. It's going to deteriorate, and you shouldn't be charged for that normal deterioration. Now, if they do withhold, they must send you a written list of the damages with a statement of what it actually costs to repair them. They have to send this to you by first-class mail within the 45 days after you move out. So it's important for you to provide that mailing address to them so that they can send you that notice if that's what they're going to do. You have no obligation to provide them the address of where you move to. If you have a mailbox or an office on campus, or you have a P.O. box that you receive mail to, you can provide that as well. You're under no legal obligation to tell them where you're living now, but you should provide them with at least a mailing address that you have access to, so you can receive that notice if they're going to be withholding from you. Now, I know we're talking about move-outs, but it's important to take steps early when it comes to protecting your deposit. Maybe you did some of these things when you moved in, maybe you didn't. That's okay, but I just wanted to talk about it so that next time when you're moving into your next place, you do everything you can to try to get your deposit back. It's important to try to do an inspection of the property right when you move in at the beginning of your tenancy. You can ask to have the landlord there to point things out to them so they're aware, but if they're unwilling to do that, then you should make sure you notify your landlord in writing of any issues or conditions that need to be repaired. Even if they are there, I would follow up with an email and say, I just wanted to confirm that I pointed out X, Y, and Z, the blinds in the bedroom, or the drain in the kitchen was draining slowly. Take pictures of anything that is able to be, documented, and just keep them. Put them in a folder in your computer, and just remember, because these are going to be the comparison. You're not expected to improve the property in any way, and so if it is provided to you in a certain way, you want to make sure that you document that condition so that the landlord doesn't try to say, oh no, that was brand new, or that was completely functional and now it's not. So you want to make sure that you have that comparative photos from when you moved in to make sure that you aren't going to get charged for them. If there are really, really significant repairs that make it unsafe to be there, I know it's a difficult decision to make, but you can ask that they be completed prior to you moving in. Once you move in, it's a little bit harder to move out and try to cancel the lease. But this is only for really, really significant things that make the unit unsafe or unlivable. And if they promise to repair something, try to get that promise in writing, and always include a deadline for when they intend to make those repairs by. If there is anything during your lease term, or even at the beginning as we're discussing, that they haven't repaired, you have options. There's something called a housing code inspection that you can get from the city or county, depending on where you live, that they can make sure that your unit is safe and meets the minimum standards of the housing code. And so if you have questions about that, let us know. If you're renewing or or moving to your new place and have some issues that your landlord isn't repairing, reach out to us and let us know. We can provide you with those resources. Now, we're talking about move out, so this is what you want to know. When you're moving out, make sure that you send that written notification, that notice to the landlord in the time specified in your lease, whether that's 30, 60, 45, 90, 120, whatever it is. Make sure you're providing that notice of your intent to move out. Contact the landlord and try to arrange a walkthrough of the unit. Take as many pictures as you can during that walkthrough. In some cases, if you do a walkthrough a week before you're going to move out, you might have the ability to correct some of the issues that your landlord is planning to charge you for. Like maybe there's a scuff on the wall from you were bringing your bike in, and there's some tire marks, or the handlebar scraped the wall, and the landlord wants you to just patch it up or do touch-up paint. You could save yourself some money by spending $15 or $20 on paint and doing it yourself, instead of having the landlord charge you $100 or $200 to hire a professional to do that. So it can be cost savings to do that walkthrough ahead of time and try to be proactive. As I said before, don't forget to provide a forwarding address to your landlord so that you can receive the check that they're mailing back to you, hopefully, or if not, a notification of what the withholdings are going to be. And you always want to make sure that you're cleaning the unit before you leave. You don't have to make major repairs or damage that you didn't do, but you should leave the unit in sort of broom clean condition. You should try to wipe down the counters. You should try to sweep, vacuum, all those sorts of things to make it look like it's in good condition, and hopefully it was provided to you in decent condition. So you're just trying to return it to that decent condition, obviously minus the ordinary wear and tear. You've been there for a year, maybe more. And so things do deteriorate slightly, and that's okay. But you want to make sure you're not leaving trash around or things like that, because your landlord can charge you for trash removal, and in some cases cleaning fees if it wasn't cleaned. Now, when your landlord withholds part of your security deposit or all of your security deposit, you do have legal options. The easiest option is, and most likely option is, if your deposit was less than $5,000, you can go to small claims court in Maryland. In DC, small claims court goes up to $10,000. So you can seek your deposit back in small claims court. Small claims court is a court that was created to make the court system more accessible for these cases where it usually doesn't make sense to hire an attorney. Attorneys are expensive, and even though a few $1,000s is a lot, it's not a lot to what an attorney is going to want to charge you. So most cases in small claims court, a lot of cases in small claims court don't have attorneys, but they've sort of eliminated some of the procedural obstacles and tried to make it as streamlined as possible for those of you who, like everyone, who hasn't been to court before, like almost everyone. And so small claims court is going to be that option. If you're in College Park, the closest small claims court is in the district court in Hyattsville. It's right on Baltimore Avenue on Route 1. It's 3 or 4 miles south of campus, right past the downtown Hyattsville, past Franklin's. It's there on the right. And so it's pretty accessible if you're driving from campus, or you could bike there. If not, there's a bus you can hop on that goes up and down Route 1. So it's pretty easy to get to. And so small claims court is going to be your best option. Depending on what your landlord did, you can also seek 3 times the amount of a bad faith withholding. So if your landlord just totally ghosted you and never returned your deposit, and never provided you any notice at all, that could be seen as a bad faith withholding that you can seek 3 times the amount of your deposit as a penalty. If that's still under $5,000, you can keep it in small claims court. If it ends up being more, you have to file in the regular civil actions. But let us know. We can advise you on that and see what makes the most sense. But small claims court is going to be where the vast majority of security deposit cases get litigated, meaning where do they go to court. If you have other questions, obviously reach out to us. We can help you, but there's also a lot of online resources. The People's Law Library of Maryland, if you just Google it, it's probably the easiest way, is a wonderful resource that's a joint project between the Maryland court system and volunteer attorneys to help simplify the law, make it seem easy, make it easier for everyone to understand. And there's also resources on the Maryland Office of the Attorney General's website that can help as well. And finally, this is us. I'm Zach from the Graduate Student Legal Aid side. There's also Cindy who works with the undergrads if you are an undergrad watching this. But feel free to go to our websites and reach out to us, fill out our intake forms if you would like to schedule an appointment. Or you can also email us. And we're here to help. That's what we're here for. So if you have any questions, concerns about your moving out, about your renewal, an early lease termination, if you want help, if you have questions about your negotiations, just let us know. We're here to help. And hopefully this provided you a little bit of information about how to better approach the end of your lease, moving out, early terminations. But thank you for watching.